The arms deal case against former President Jacob Zuma is back at the Pietermaritzburg High Court. The former president is facing charges of corruption, money laundering and fraud. He was first charged in 2005 and then later again in 2016. He says these charges are politically motivated. For more on this, eNCA's Thulasizwe Simelane joins me from outside court. Now, Thulasizwe, everybody seems to be ready, including the former president's lawyer, Moses Kakane, but there's another delay. Why this delay today, and are we likely to see anything happen in court?
Well, Maseko, in the next half an hour or so, usually around 9:30 thereabouts to 10 o'clock is when court processes really get underway at the High Court here around this particular matter in particular. But in this case, not much is expected to happen inside the courtroom. The action will be pretty much confined to the judge's chambers, which is where this whole issue of the postponement is likely to be confirmed. We understand that it will be a postponement partly to accommodate a separate application that Thales has brought challenging the charge of racketeering that has been proffered against them by the National Prosecuting Authority. Basically, Thales making the argument that you have not been able to present as the NPA even prima facie evidence that can sustain a prosecution on the charge of racketeering. And I'm joined by Mpumelelo Zigalala, an attorney, to unpack some of what we can expect in this particular case. Before we talk about racketeering, Mpumelelo, let me ask you, how unusual are these kinds of delays, right, in the process of the pre-trial processes? Is this unusual that it takes this long to get to a point where that's it, it's certified as trial ready?
I would say in most cases they usually start and finish within a reasonable amount of time. But on this one, you would understand what is at stake. You would understand the litigants that are at stake or that are involved in this matter. They want to make absolutely sure that they are ready. They want to make absolutely sure that, well, you may say they try and avoid going to court or going to trial as much as possible. So they would want to explore all the avenues that are there. But another view that you can look at is that they want to make sure that all their rights are exercised and are protected along the way. So if there is an opportunity for them to exercise their rights as per the Constitution, they would certainly want to explore that before moving into trial. The
logistics of, preparing and doing pre-trial processes in the age of COVID-19 and the lockdown, the various levels of lockdown. When we were here in June, we were at a much higher and much stricter level of the lockdown. It's since eased. But I do recall the conversation being about, the difficulties of, for instance, when Thales's defense team says to the NPA, you need to give us further documents, going as far back as 1999, thereabouts, and there are thousands and thousands of documents in this particular case, and you have Billy Downer saying that actually even that becomes difficult because the people who work with the documents need to go into actual buildings, and sometimes at that point it was difficult. What are some of the challenges of doing this pre-trial process in this challenging period?
The most challenging one is the interviews. You must remember, if you have a witness that you want to give evidence later in the trial, you need to prep them. You need to find out what exactly happened, make sure that their witness statements are coherent, they understand fully what took place. If there are issues of clarity that have a bearing on maybe on the matter on which the legal line that we are going to take at the end of the day, we need to consult with them. So the number one is consultation, which can't be really sort of smooth when it's done by, let's say, Zoom or Microsoft Teams. However, all other documents, which is analyzation of documents and other statements, I think they can be done using the modern technology that we have. One should actually say, if the parties are really interested in making sure that this process starts and ends within record time, we should all come in and make sure that they lend in a hand and they do an extra amount of work in order to make sure that they are ready. In this case, for example, today's postponements can be clearly sort of put in within the space or within the ring of the judiciary. Instead of saying, if you had released this judgment earlier, let's say 3 weeks or a month ago, you would have been able to come today and come with a clear line in terms of saying, we are ready to hear you. if you are ready, let's put a date in February so that we're able to ventilate all these issues and get this trial over and done with within the record time.
And when we're talking about that, how much of a spanner in the works does this separate challenge by Thales to this racketeering charge, how much of a spanner in the works is it in the main criminal case, State versus Zuma?
It's a huge spanner in two ways. Firstly, with regards to delays, you must remember, if they are not happy with the decision that will be released by this court, they have the Supreme Court of Appeals, they have the Constitutional Court. Give that process plus minus 6 to 8 months before we are back here again with the pre-trial. Secondly, if they are successful in their challenge, then it throws a spanner in the works on the side of the NPA, because they have to rework their strategy now in terms of saying, because we only have one accused that is there, how do we make sure that the people or the evidence that we are going to leave guarantees us a guilty verdict at the end of the day?
Yeah, because it's difficult to convict someone of racketeering. You need to be with other people that you form common purpose with,
yes,
to engage in the activities of this criminal enterprise, right?
Precisely. It's a two-way process. So you need a person who's going to participate with you. Now, if you are alone, then it becomes a bit of a challenge in terms of proving it, especially with this principle of saying that it must be proved beyond reasonable doubt.
Yeah.
Once there's doubt, then there's definitely a not guilty verdict that is going to come.
Okay, lastly, I know that I'm putting you on the spot here, but Mpumelelo Zikalala, in your best estimation, from your experience, when are we realistically likely to have the first witness called in this particular matter, if at all?
I would have said a few months ago, 2021. Now I'm saying the latter part of 2022.
Geez, later part of 2022.
That's the.
Mpumelelo Zikalala, an attorney here in KwaZulu-Natal, a legal expert, sharing some of his experience there, as you can hear, Masiko. Because, the goal right now is to get the matter certified as trial ready. But we're moving at snail's pace even to get there. And perhaps even a snail moves faster than what we are doing, because there are days when we don't even move an inch. And I think today will be one of those days where we are in court, but there's absolutely no movement. There are processes, of course, to exchange documents. There's that separate court matter that has now been heard and is awaiting judgment. And it's likely that when that judgment comes in, the Thales judgment around racketeering, when that comes in, it may be the key that opens the door, but the door has a long corridor through which we have to walk up to actual certification of the trial being, the case being trial ready. And even when it's certified, Billy Downer also indicated that it's not like we certify and say it's trial ready today and tomorrow we are back in court. There's another leg period after that for the logistics to be worked out of when and how exactly this trial will be conducted, and arranging the witnesses in terms of the sequence in which they will appear. So, long way to go.